Regulating for Results that is hosted by the Center for Information Policy Leadership, the Center. I think most of you know the Center. The Center is a global privacy and security think tank group which is associated with the law firm Hunter Williams and is presided by Bojana Bellamy. And it really acts as a platform for engagement between all relevant stakeholders, including industry leaders, governments, academics, regulators, and policymakers. And as an example of what actually the Center is doing, a couple of days ago, earlier this week, we were actually in Dublin, where the Center organized, together with the Irish Data Protection Commissioner, an event for SMEs in order to really explain to SMEs how to operationalize and how to implement the GDPR. So it was a really practical workshop. And it was actually a very successful workshop where SMEs could take practical tips as to how to implement the GDPR. Now, why this topic, regulating for results? We tend to focus on how companies need to implement the GDPR and how it's hard, how it actually requires a lot of effort, how little resources we have, and how painful it is. So who has never complained about the GDPR? Raise your hand. Now, have you ever thought about what it means really for regulators? Because for regulators, it's also a monster regulation, right? The world has become digital. Data is everywhere. So where to focus efforts, where to focus resources? And DPAs might also be flooded by requests, questions from consumers, complaints, and data breach notifications. So the aim of this panel is really to stimulate a conversation as to how DPAs can maximize their effectiveness so as to reach the best outcomes for individuals, for organizations, and for society in general, so as to achieve smart data protection. And so that will require to make difficult decisions, difficult choices about strategies and about priorities, because DPAs will not be able to do everything. That's just not going to work. And it also involves engaging with and supporting organizations who are trying to do the right thing, who are seeking ethically to get it right. So we will further explore this topic and all those questions, and we have a fantastic panel to do so. So let me start on my left. We have a moderator, Hielke Hijmans, who is independent legal advisor and researcher on fundamental rights and EU data protection. He's also a senior policy advisor at CIPL. And before that, Hielke was working at the EDPS, where he was the head of unit policy and consultations. On his left, we have, wait a minute, let me focus. Wojciech Wiewiorowski. I practice, but I don't know. I need to practice more. He's Assistant European Data Protection Supervisor, as well as Adjunct Professor at the University of Organised. And before that, he was Inspector General for the Protection of Personal Data at the Polish DPA, as well as Vice Chairman of the Working Party 29. On his left, we have Wilbert Tomesen, who is a member of the Dutch Data Protection Authority, as well as, and he's also serving as Vice Chairman. Then we have Julie Brill, who most of you may know. She's Corporate Vice President and Deputy General Counsel for Global Privacy and Regulatory Affairs for Microsoft. Prior to that, Julie joined the global law firm Hogan Lovells as a partner and co-director of its privacy and cybersecurity practice. And before that, Julie served for 6 years as the Commissioner of the Federal Trade Commission. Yes, and then last, I'm sorry. You have made my life more complicated.
Who has? We're just sitting where our tags are.
No worries. And last but not least, we have Elise Moyer, who is the head of Institute for European Law of the KU Leuven, and she's the full-time professor of European law. On that note, I will give the floor to Hielke, who is our moderator.
I will also introduce Richard Thomas, but he also represents.
It's a hard job to be a chair, I'm telling you. So, I'm sorry, Richard. Everybody knows you, that's the reason why. So, Richard was a UK Information Commissioner until 2009, and he's now Global Strategy Advisor at the Center. The best for the end, Richard.
Yes, just a few words why we are here. We are basically discussing a paper which we presented a few months ago by the Center of Information Policy Leadership, Regulating for Results, a paper which aims at stimulating the thinking on how DPAs should work within the GDPR, but also more on a global scale outside of Europe. Should work is the question I have here, because of course it's not up to us outsiders to decide how DPAs should work, but we hope to be, as center, helping in helping the thinking and helping and provoking some ideas on how we can all make this work better. Of course, the GDPR will be the big game changer as of May. 22 tasks, we all know it, 22 tasks, and it's a very difficult issue. Yesterday, the Commission presented a communication on where we the state of play on data protection in Europe, and one of the things the Commission clearly emphasized is that the DPA function is extremely important. But it also mentioned that in not all member states it is sufficiently supported. There are sufficient means in all member states. So there is an issue to think about resources, but also how to use these resources in the best way. And it's the last way, the most important emphasis, the most important aim of our paper. The Commission said that member states are right on the good way, but there is still a relative imbalance between member states. So not everywhere it's going well, but some places it is. The paper, which we presented some time ago, I really recommend those of you who did not have the chance to read it at a certain moment. Has a few key topics. Richard will explain that more in detail. But one of the things we would like to think of is how all these tasks of DPAs, the 22 tasks on enforcement, but also on awareness raising, also on advisory tasks, how that could be done in a strategic way, and how DPAs, at least in Europe, but also outside of Europe, can do that in a way which is consistent and is helpful in delivering data protection, because that's where we all are for. Our paper is built on the notion that effective data protection should not be built on just enforcement using the high fines which are in the GDPR, but there's also a number of other elements, engaging with parties, engaging with controllers and processors could help in delivering and making things better. Also because DPAs, if they engage with controllers and processors, they start better understanding what's really out there and how the world is like in this area. So fines should not be the only thing. The paper is based on theory of Professor Christopher Hodges from Oxford University, who really thinks clearly that we should never have fines. I think life is a bit more complicated than that, but it's the basic idea is that by engaging with the controlled parties, you can, as a supervisor, better do your work. And that's the thing we follow up. A few other things we will mention in the paper. A thing which is quite challenging is always is how DPA should handle complaints. The complaint handling function is an important function of DPAs, also emphasized in the Schrems case. The first Schrems case, I must say, of today, because since today we have 2 Schrems cases in the by the European Court of Justice. And to what extent DPAs should do this, and to what extent can they avoid that complaint handling takes over their whole work? Those are questions I think we would like to discuss here as well. Our key term, our key word, our catchword today is constructive engagement. That's the key of our paper, engaging on basis of trust between the supervisors and the ones they supervise. I am very happy, and in that I repeat Caroline, that we have an excellent panel here with people who really know what they talk about, rich experience in the DPA world, but also academic knowledge and also experience outside the DPA world, also in the private sector. I would like to give the floor now first to Richard, who will further explore the work we did. And I don't reveal a secret to many of you. This work is really Richard's baby, and he loves to show that around.
Well, thank you. Thank you very much, Hielke. It's a pleasure to be here this afternoon. I have put together a few slides, and I hope we just move to the slides just to give some framework to my remarks. Yeah, here we are. The paper is on the CIPL website, and I do hope some of you will look at that and respond to that. But it tries to address some what I call infrequently asked questions, questions not asked very frequently, whether by academics or by anybody else. What, in fact, are DPAs there for? What do we mean by effectiveness? What results are they trying to achieve? What does success look like? And the key question for today, really, the key question of the paper, how can effectiveness be maximized within the context of increased responsibilities, particularly, of course, from GDPR, and limited resources? And we argue, I think, quite strongly that DPAs simply cannot do everything. It would be impossible to do everything set out there as a duty or as a power. Within GDPR, there are 21 separate duties and 27 separate powers and very large numbers of data controllers and data processors and huge numbers of data subjects. Their resources generally are meager. We've done some calculations in our paper showing what resources are available. They have increased a bit since we wrote the paper, but still, I would argue, the resources available to DPAs are still very small indeed compared to what is needed. So I think that any DPA, any regulatory body needs to set its strategic priorities. To use the slogans we've used in the past, we repeat them, they need to be selective in order to be effective, and they need a results-based approach with clarity about the results they're trying to achieve. And looking at this negatively, unless you've got clear strategies, there are clear risks. Risks of overwhelmed and therefore ineffective data protection authorities, individuals who are not adequately protected, confused and frustrated regulatees, those being regulated, and at the end of the day, reputational damage for both privacy and data protection. As Hielke mentioned, we worked closely on this paper, drawing upon the work particularly of Professor Christopher Hodges from Oxford University. He's written a book published 2 years ago, 800 pages on effective regulation. And it's a global study, looks at studies right across the world of virtually every other area of regulation: financial services, workplace safety, transportation, communications, food safety, and so on. But no mention, no chapter in his book on data protection. So since his book was published, we've worked with him to try to apply his empirical findings and his theoretical approach to the area of data protection. And this slide tries to summarize the key lessons from elsewhere. First of all, the approach taken by the regulator is just as important as the content of the rules they're supposed to enforce. Secondly, you need to target the behavior of organizations and understand how organizations behave in practice. Outcome-based, risk-based approaches produce better results than just going for compliance for its own sake. And perhaps the key message for today, that deterrence and punishment, strict law enforcement if you like, have limited effectiveness except for the worst cases or as a last resort, and that a better approach is a focus on encouragement, support, and what is called voluntary compliance, where people actually want to get it right, to encourage that mentality, more effective than law enforcement. And I think also a growing recognition that the vast majority of organizations, for reputational and other reasons, want to comply with the law. They want to get things right. And the role of the regulator is to try to enforce and encourage that approach. So in our paper, I'm summarizing very quickly indeed, we set out 4 main categories of functions for data protection authorities. We've classified the various duties and powers inside GDPR under these 4 main headings. And we've argued that the top priority should be for the leadership function, which involves constructive engagement with those being regulated. This involves guiding and supporting good practice and engaging with those who are being regulated, who of course now have new obligations of accountability, and this fits very closely with the principle of accountability. The police officer role should not be the first port of call. It should, we argue, be reserved for deliberate, willful, or seriously negligent conduct. When I was the British Commissioner at the ICO, the slogan we had there was along the lines, "We are here to help those trying to get it right, but we'll be tough on those who are not trying." Complaint handling is a difficult area. It is demand-led. You have no control over what complaints come in, the volume or the type of complaints. It is very resource-intensive. And I can tell you that having very large numbers of complaints with backlogs building up is not healthy for any organisation. So we argue you need to have triage arrangements, selection criteria to avoid being swamped by complaints. And what you need to do is to identify those complaints which do need to be investigated, the more serious ones which can carry the mission forward, and also those which can be used as a source of intelligence. So you need to prioritise within the complaints coming in. And lastly, the authorising role, where the DPA is there to authorise particular actions. We argue that's not a particularly strategic role, and that should be kept to a minimum if a DPA is to be effective. My time is running out, so I'll just briefly go over the last couple of slides. We elaborate a whole section of our paper. What do we mean by constructive engagement? And this slide just gives you some examples of the sort of behaviours we'd like to see on the part of data protection authorities. Transparency within themselves, practical guidance, aiming to help organisations get it right first time. A lot of consultation, a lot of frank exchanges, more and more reliance, as in other fields of regulation, on self-assurance, which can be regulated in itself. Exploiting herd instincts, identifying those companies which will be followed by other companies and getting them to get it right so that the herd will follow behind. And then regulatory sandboxes, an idea increasingly being used in other areas, where you create a space for new ideas to be developed, responsible innovation, still staying within the parameters of the legal framework. We even have a picture in our report which shows what we mean by constructive engagement. You'll see at the top there the context, the role, which cannot be neglected, of media, market forces, political forces, civil society, certification agents, DPOs, redress schemes, ethical business regulation. All these are important pressures, but at the centre must be that relationship between effective DPAs and accountable regulatees, and no one should ever forget that the real benefit is for individuals and society. That's why everybody is there. So to conclude, I emphasise our paper is a discussion paper. We are not telling DPAs how to do their job. We're feeding some ideas which have not surfaced before. We go on in our paper to suggest some principles and a protocol, but these are there for discussion. And we've raised 10 questions which arise out of his thinking, and we're hoping that some of these will be addressed at this year's international conference being held here in Brussels under the leadership of EDPS in October this year. Thank you very much.
Thank you, Richard. I would now turn to the DPAs themselves, the two still active DPAs here on the table, who could react on the ideas presented by Richard.
Thank you very much. Thank you for possibility of being here with you and to say a few words on the data protection authorities' approach to the problem of their own effectiveness and pros and cons of the things that were highlighted by Richard in his studies. Let me start from being a little bit heretic to the subject that was proposed. I agree with Richard and with findings of CIPL that results are first of all to be assessed. So we have to know how to assess the effectiveness of the data protection authority. That's true. That's true also that we have to check and we have to count the real effectiveness of the data protection authorities. On the other hand, and that's this probably heretic part, the effectiveness itself and the results are not the golden calf. That's not the only thing that we have to take in mind. We have to remember that the data protection authorities are not the commercial entities that should gain the success in the end, which you can count by numbers, or you can count by the influence. They are also, and maybe first of all, the defenders of the fundamental rights, which means that they cannot commercialize them and they cannot choose only these fundamental rights, these aspects of fundamental rights, which are easier to be assessed and easier to show that they are the good result and they are showing the good work of the data protection authority. In my previous life as a data protection authority on the national level, I had an opportunity to take part in the project which was called FEDRA and which was presented at Cpdp conference several times, because we tried to find out what is the situation of the data protection authorities in the world, what is the situation of data protection authorities in Europe, in FEDRA too, and find out what is the effective way of cooperating of these data protection authorities. So the effectiveness is something that we were always taking in mind, that I was always taking in mind, and which is also extremely important right now when we are preparing the work of the European Data Protection Board. So I will not talk today about the resources, I will not talk today about being local and being European at the same time. I will not talk about the problem of a number of international forums that we have to take part in. I will not talk about the cooperation with the civic society. I will not talk about different procedures in different countries. I will not talk about collective redress and the possibilities and differences in different countries. I will, in the end, I will talk about the problem that we talk very, very rarely, which is how the courts will react and how the data protection authorities will be reviewed in the judicial review by the courts, who are not bound by any kind of guidelines, neither from the Commission nor from the European Data Protection Board. So what I'm going to tell about in this few minutes that I still have, 5 minutes and 5 small topics: guidelines, the consistency procedures, enforcement, the specific situation of the data protection in the institutions of the European Union, and finally these codes that I said about. I skipped comments about the budget because it's not very easy for me to discuss the problems of budgetary expectations of the data protection authorities. Guidelines. Guidelines and opinions from the European Data Protection Board are one of the most important tool that we want to use in order to be effective as data protection authorities. And it might surprise the people in the audience, but in my personal opinion, the guidelines are not prepared for the market. The guidelines are not prepared for the business. They are not prepared for this kind of addressees. First and main addressee of the guidelines prepared by the European Data Protection Board are data protection authorities themselves. Because the main symbol of effectiveness and main achievement that we can get is the situation where the GDPR will be implemented and interpreted the same in Tallinn and in Madrid, in La Valletta and in Stockholm, in Warsaw and in Paris. And that's the biggest challenge for data protection authorities if we think about their effectiveness. Because we then have to compare if the Cyprus authority is effective enough in comparison with ICO, or the French authority, is it comparable with the Estonian authority. So definitely the works that we do right now in the working party of Article 29, preparing the documents which will later on become the guidelines for the European Data Protection Board, are the first tool for effectiveness that we want to prepare. And the second point of the works which are not that visible in the world, but which are right now the core of the activity of the Working Party of Article 29, is to deal with all the international procedures that we will have. Not only those of the full consistency mechanism in one-stop shop system, but also the situations where there are only two data protection authorities from two countries that are involved in the case, and they will be solving the case, but this case will be a kind of precedent for the things which the other data protection authorities will do. What should be the involvement of the parties? What should be the involvement of the different sides of this conflict? Enforcement. I absolutely agree that enforcement, which is quite new for some of the authorities, cannot be recognized as the main armor in order to be effective. So you cannot count the effectiveness of data protection authority by the number of fines, by the amount of the money that was paid, by the amount of the amount of the cases which went to the court and to which kind of court. We shouldn't expect that the data protection authorities will sit on 26th of May and will start to choose whom to punish. They will not do that. Definitely this is not their goal. But on the other hand, we have to remember that on 26th of May, the first complaints will come to the data protection authorities, and they will be proceeded with the new law, including also the new tools and the new enforcement solutions that the GDPR proposes. So it's hard to count and it's hard to assess if we don't make the overall plan for data protection authorities how many cases you should start yourself, but you are all somehow relying on the number of complaints that you will get. Of course, I'm not saying that the data protection authorities will not work ex officio, but this is definitely not the thing which is the most important for them. And specific thing for the data protection in the European Union institutions, that's maybe not the most important moment to say that, but we have to be with in mind if I'm answering the question from the EDPS point of view. We have to remember that the institutions and the bodies of the European Union are not under GDPR. They are not bound by GDPR. They are expecting their own regulation, which is right now in the trialogue between the Council, between the Parliament and the Commission. And we would like to send once again the message: we need to finish this work as soon as possible, and we need to have this document as soon as possible. Otherwise, we will be in a very hard situation to assess ourselves as EDPS. And well, I said about the problem of the court. I see my time is running out, so maybe we'll come back to that in the questions. So let me just say two sentences in the beginning. First, we should not forget, as data protection authorities, that we are regulators. So the work of the regulator, not a teacher, is the most important thing that we should do. And that's also the way that we should assess the effectiveness of the data protection authority. We should be open, and we should be open also for the critics, also for those who are criticizing our own behavior. I'm very happy to have Simon Hania here with us. He was very critical towards the EDPS in his tweets a few months ago, but we invited him for the speaker at our next conference, trying to show that we are open in the discussion about the effectiveness and the practice of the European Data Protection Supervisor. And finally, in the end, something which we definitely can learn from non-European data protection authorities is the way to assess the work of the Data Protection Authority. I have to say that I was really astonished by the way that New Zealandic authority is doing that. How do they count the influence of their own decisions and or their own work? How they collect the reflections from the market about their activity, and how they then improve their work, which does not mean to agree with all the critics, because sometimes the critic comes only because they are a little bit too effective in some of their work. Thank you.
Okay, a little bit more than 7 minutes, but very interesting what you did. This was Wojciech, very good. Wilbert, also you look at it from a member state
Yeah.
How does a national DPA work? Please go ahead.
Thank you, Hielke, for having me on this panel, and indeed for the possibility to speak from the perspective of a DPA who is in the midst of a process of change, in the midst of adjusting to new challenges. What I would like to do for the next few minutes is to inform you about the developments at our Dutch DPA, the changes we try to implement, and indeed to touch on some very, let's say, topical subjects without having rigid answers to all the challenges that you rightly so summed up just a couple of minutes ago. And even if we for a moment would set aside the GDPR, all privacy regulators have to deal with in an era in which technological developments go so extremely rapidly. And that is a domain, a supervisory domain that ranges from small businesses to worldwide operating multinationals, small municipalities to national governments. And of course, we all have to deal with a limited budget, with limited resources. So, for instance, in The Hague, we indeed constantly have to make choices, which, by the way, on itself, in principle, is not, let's say, an unhealthy situation to having to make choices. And the most eminent choice right now is our way of supervising, so that we effectively influence the controllers, the ones being supervised, that we successfully promote the core ideas of data protection, and that at the end of the day, citizens know their privacy rights, which they can indeed exercise, in short, that they are empowered. And we are, and it feels like that, it literally feels like that, in the middle of making those choices of that big transition. And we, as all regulators, I guess, in our supervision, we use and try to use a mix of instruments. In general, we, of course, want to take up this leadership role, and we want to provide practical information and guidance to controllers. And we feel the urge to guide and eventually help organizations to comply with the new upcoming obligations. Not, and that is because that in fact is impossible, by providing them with case-by-case, almost personal advice, but while paying particular attention to the context with branch organizations, via providing extensive information, guidance regarding the upcoming norms, and we do so via our website, of course, via telephone, and an extensive information campaign from next week on, even with ads on radio and TV, and of course via a lot of presentations and speeches all around the Netherlands. And in addition to providing this leadership, which also Richard Thomas mentioned, to inform and to guide, we supervise, literally supervise, of course, and the way we monitor and supervise is also changing. Since the beginning of this year, since a couple of weeks also, so we have a new brand, a new department in our office, which will not focus on investigating violations, but aims at being in, as I tend to call it, in a systematic and cyclic contact with organizations. We want to influence those organizations to check, for instance, on a constant basis where the internal processes, as far as the handling of personal data is concerned, are well organized in terms of the GDPR. Has a DPO, for instance, been appointed if necessary? How is it functioning? How is the data protection impact assessment being used? Something else is that we have recently installed a special department that specializes on security and technological issues. We are simply dealing with lightning fast technological advancements, and not only do we need to keep up our knowledge regarding these developments, also do we feel the need to keep up with new trends, better to see them coming in time. And we certainly have to be a solid conversation in the Netherlands, a solid conversation partner for stakeholders, law enforcement, for instance, in this important area. And then in this concise overview with the choices and the things we are struggling with, let me mention one more puzzle, and that is indeed the upcoming, the tricky, very important obligation to deal with every complaint from citizens that is to say, to the extent appropriate. And this clearly can be an effective way of filling the obvious gap between the individual on the one side and the data controller on the other side. And proper complaint handling supports what I see as a core task, empowering, I mentioned it before, empowering the individual. But, and there is a very big but, how do we manage the amount of complaints and the follow-up? And how do we prevent ourselves from drowning? How can we make complaint handling serving to our more general task of showing leadership, of guiding and supervising? And then preferably to the extent that it increases, at the end of the day, the confidence that individuals have in companies, in government, basically in society. So we are investing in developing new strategies and therefore building new departments, organizing new specialties in our organization, and obviously we do need additional financial resources to accomplish this. And the approach we have chosen in the years behind us to realize this is the following. We have entrusted a quite well-known consultancy firm to look at our work processes, to look at, especially, of course, our new GDPR tasks, and to make an assessment on how much manpower, how much capacity would be needed to perform our current and especially, of course, our new tasks. And the results of this exercise we have submitted to the Ministry of Justice in The Hague, from which we receive our annual budget. And I must say, up until now, this has proven to be a quite fruitful approach, since we indeed have received a substantial increase of budget. Not everything we wanted, of course not, but you can't have it all. Important is that with the ministry we have agreed to monitor our developments, so if need really be, there is a willingness to again look at our budget, and we're now in the midst of growing from approximately 80 people towards 130 people. I guess we will have on board comes May 25. So Hielke, let me conclude for now by emphasizing that we are trying to organize this multiple approach. Very roughly, you could say, consisting of the carrot, Hielke, as well of the stick. We provide information and guidance, try to give leadership, but we will certainly act in case of serious infringements. Imposing a fine in this context is certainly not our main goal, but certainly, again, an important tool to ensure compliance. The instrument of fining, in essence, as I see it, provides us with the proper role and authority. So we want to provide guidance as much as we can, but we certainly also want to act vigorously when necessary. In the end, both approaches, Hielke, are needed to properly do our work to protect the fundamental rights of citizens. Thank you.
Okay, thank you. This sounds very promising. And I now give the floor to Julie, who combines the expertise of a non-European authority, the Autoriteit Commission, and now she works for Microsoft. So.
Thank you so much, Hielke. Thank you, Richard. This is a really interesting discussion, and I'm hoping we can get to an actual conversation. So I'm going to try to keep my remarks relatively brief and at a relatively high level. It is true, I have never been a DPA in Europe, but I know a lot of you, and I've worked with many of you for many years. I was at the Federal Trade Commission, which is the United States' leading privacy enforcement agency, but I was a commissioner for 6 years, but what's so interesting about the FTC and what really makes it very different, I think, from the European DPAs is the FTC has a very broad remit. It's not just privacy, it's also consumer protection, and it's also competition, and I want to bring that into the discussion in a moment. But let me first address some of the things that we heard from Richard and kind of best practices from my perspective for DPAs. And for full disclosure, of course, I was a commissioner for 6 years under the previous administration, but for the last about year and a half, I have been in the private sector. I represented a lot of large companies as a partner at a global law firm running their privacy and cybersecurity practice, and got a lot of interesting insight into a whole number of companies. And for the past 5 months, I have been at Microsoft, one obviously very important player in this ecosystem, running their global privacy and regulatory affairs program. So let's talk a little bit about the leadership function that Richard mentioned. In my view, you really cannot separate the leadership function from the police function for the following reason. No one's going to listen to you as a leader unless you actually have a stick to back up what you say. People will pay a lot more attention to you when you say something about whether it's privacy or whether it's a particular interpretation of the GDPR or a provision within the GDPR, if it turns out that your view might have a deep impact on the audience. And the way you have an impact, one of the ways you have an impact is through an enforcement mechanism. So I think there is an important relationship between these two functions that can't be ignored. And that actually, I think, feeds into how important the leadership role is of DPAs and other enforcement entities, because you do have that stick, and potentially, and especially now under the GDPR, a very large stick. It is very important to exercise that leadership role, to communicate to businesses, to consumer groups, to other governmental agencies, and frankly to your fellow regulators around the world, what your view is of how the law works and how it works with respect to or in relation to other laws, because you do play such an important role in the enforcement regime. So I think the leadership role, honestly, has been a, how can I say this? I think the DPAs here in Europe have wanted to exercise that leadership role, but haven't necessarily had the resources or the time to do it. And I'm not certain that with the new remit that they have and the incredibly greater responsibilities that they're going to have to enforce this law, that they're going to have even more time to do this. But I think it is very important that the DPAs do take this up. So what does a leadership role mean? I think a leadership role entails holding workshops, addressing issues that are somewhat ambiguous in the law, trying to bring clarity to the regulated community, and not only to industry, which is the regulated community, but also to consumers and NGOs, so that they understand what the ambiguous areas of the law really mean, or at least how they're going to be interpreted by the DPAs. I think leadership also involves having an open door policy. One of the things that I tried to do at the Federal Trade Commission was really listen to anybody who wanted to talk to me. You know, literally anybody. If I thought that they had something that they needed to say to me and that might be useful to me. And that open door policy, I think, did me really well over the years. I think I learned a lot. I learned a lot from all sorts of stakeholders, everyone from Max Schrems, who came into my office a number of times, and I served him lemonade and cookies, to some of the very largest companies to whom I also served lemonade and cookies and listened to what they had to say. So I think that open door engagement is important. But let me go back to the police function for a second. And I think Wojciech mentioned that it's important from his perspective not to just tally up the number of cases that you bring, but to really be sort of selective about the cases and really make sure that they have an impact and do something important. I completely agree with that. I think that that's an excellent point, so I want to underscore it. I think it is important that any regulators sometimes lose cases. You'll never know that you have pushed the law in the ways that you think it needs to be pushed unless you occasionally lose a case. If you're just bringing one easy case after another easy case, you know, you're not really helping the regulated community because we don't know the boundaries of the law, and also you're really just engaging in sort of point scoring. And by what I mean by pushing the law, I don't mean going into new areas that the legislature or the parliament here never intended, but rather helping develop those gray areas where there is ambiguity in the law to try to bring some clarity to it. Having said that, as Wilbert pointed out, when you go to your parliament or your legislative body as a regulator and you seek new funding, they're not going to really want to hear about the cases you've lost. Or they're really not going to want to hear about how you've spent, you know, half of your budget and half of your resources bringing an incredibly important case, and at the end of the day, you actually ended up closing it because you realize that after investigating it and whatnot, the practices that were under investigation were actually appropriate. So there's going to have to be a balance here as the DPAs are approaching their parliaments and their legislatures and whatnot to seek more funding. Okay, I want to close. There's so much to talk about here, so I'm actually really looking forward to the conversation. But I just want to give one shout out to the need, I think, for true leadership by the DPAs to consider not just the fact that they are enforcing fundamental rights. They are. Privacy is a fundamental right. But there are aspects of the GDPR and other privacy laws here in Europe that touch upon competition and touch upon other areas that bring a broader context to what the DPAs are considering. So as you consider AI and as you consider data and as you think about these things in a broader context, I think it is important to consider the global economic impact of what you're doing, which doesn't mean that you're not going to go forward with a case, but it might color how you talk to the parties that you're dealing with. It might color the kind of redress you're seeking, and it might indeed color guidance as you're developing it. I'll just give one very brief example. Portability. Portability, is that really a privacy right? I don't think so. I actually think it's a right to exercise control, which arguably is a component of privacy, but it really, in my view, was a statement that the Commission, the European Commission, and the Council and the Parliament were making about the need for competition around data. So if the DPAs are going to be enforcing competitive aspects of this law, and some of them are deeply competitive in nature or founded on competition principles, I think the DPAs also need to consider what are appropriate actions that should be taken in a competitive landscape, how the courts are thinking about competition, and really what is a very, very complicated topic. So I'll leave it at that and look forward to the discussion.
Thank you very much, Julie. This was really a lot. We learned about leadership, true leadership, taking into account competition, taking into account fundamental rights. Really a lot of areas. Thank you very much. The last word is for Elise in this round. Elise Moyer is an academic, so we hope to have some really high-level, beautiful debates.
Well, you can hope. Well, thank you very much for this invitation, and more than anything, thank you for the paper, which I've really read with great interest. So congratulations to the authors, and I can only encourage you to have a look at it. So my comments, my thoughts here will really try to respond to certain aspects of the paper. And I think in a constructive way, very much along the thinking that was proposed, focused on leadership. Let me just maybe say very briefly where I come from. I'm anything but a data protection lawyer, and I think it's important to say that, because I'm a complete outsider to this panel. So the comments I'll be making relate to the reflection that Richard, Thomas, and Hielke have triggered on the role of national watchdogs. In a more general term, national watchdogs trying to convey a new legal culture at national level. So to convey some new rights and obligations for private and public actors at national level, which are taken from the European Union level above them, right? So that calls, in my view, and the paper in that sense, calls, in my view, for three remarks. In the areas of law where I've reflected on this, which were EU equality law, where EU law also relies on national watchdogs, which are equality bodies, in my research, it became quite clear that one of the big problems with the effectiveness of equality law at national level, so I could imagine with data protection law one day at national level, is that certain legal cultures are allergic to these rights and obligations imported from above, from a culture that is completely foreign to them. So in that sense, the function that you identify for DPA's leadership, which is really to convey information, to change the legal culture, is, I think, key. So what I wanted to say on that is, indeed, never to underestimate these resistances to foreign imported legal concepts. Now, how far do these resistances go? from, again, a series of interviews and prior exchanges with legal services from national equality bodies, it seems that in certain countries such as France or Germany, judges, lawyers, unions will not engage with European law, such as European data protection law in that case, if they have not been trained. So the depth of leadership, the scope of leadership you need to engage into, I think, is extremely broad. And we're really talking here about a very ambitious agenda. So that's, in that sense, I really can only join this call for leadership beyond litigation, and that relates to my second point. In the paper, I thought that you were thinking a lot in binary terms, regulators and those being regulated. So your focus was on talking to those being regulated, and I completely understand why. But having said, as I just did, that the resistances to foreign imported legal concepts are so deep, I would sort of encourage you to reflect more intensely on the intermediaries, which I think is what you're trying to do when you refer to constructive engagement. But it seems to be coming at a sort of an addition at the end of your reflection more than as a core part of your reflection. Although it would seem to me that other players, other forces, indeed, as you can say, as you do say in your paper, are actually key to making the real change, the underground, the long-term change. And in that sense, indeed, the regulation itself, the data protection regulation itself is trying, I think, to activate a number of other entities, NGOs, but I mean, you could think very broadly. So I wonder if the next exercise in your reflection could be to actually try to map out more rigorously who are the peripheral actors that can help you in your task and that can assist DPAs in their tasks. In the field of EU equality law, clearly there are interesting interplays between trade unions, NGOs, equality bodies, on which certain equality bodies have relied a lot for the efficiency of their strategies. So I could imagine DPAs could also benefit from this. And finally, a third point, which comes back a little bit to one made by Mr. Wiewiorowski, and perhaps slightly to be contrasted with what Julie Brill just concluded with. Again, coming back to the paper, I was struck by the paper. The paper, it seems to me, approaches the role of DPAs very much as market regulators, so as I think Ms. Brill was calling for. On the other hand, I wonder if there could be a deeper reflection on the role of DPAs as fundamental rights agencies. I think that, and the earlier speaker has explained what kind of differences this could make. And I do think this is something to keep in mind. In EU law and in the logic of DPAs, it could be very logical, and that's what you're doing, and I understand, to connect with consumer watchdogs, competition authorities. Data protection is about regulating the market, yes. But data protection is new design, is also about protecting certain fundamental rights. And it seems to me very important when you think about the design of strategy for DPAs to engage with actors who are concerned about fundamental rights. And to involve them in your clearinghouses or other experiments on the reflection on what to do next. So these were just the 3 points I wanted to share to trigger the discussion. Thank you.
Thank you very much. It's now time for a discussion. It was a lot about leadership and what this leadership should entail. I think the last point made by Elise, I heard this these days a lot before, was the idea of a clearinghouse where stakeholders of different areas work together. Maybe that's something to reflect on as well. I would like to ask basically all how you see, if you see leadership indeed all as carrots and sticks, and how these carrots and these sticks, how they should be balanced, basically. Wojciech.
I'm not sure if the carrots and sticks system is the one that should define the leadership in this field. That will be a little bit pathetic, but I would say that that's rather the knowledge and the skills of the Data Protection Authority should decide if we take him as a leader, if we take her as the one who should prepare this new path. Of course, data protection authorities cannot forget that they are the regulators, and if they are the regulators, then it means that the stick has to exist, and the stick has to be active, and the stick has to be in the hand of the regulator. That's why I said that we should remember that and not trying to be a teacher. We are not the teachers. We are not the ones to explain everything. Moreover, this explaining is sometimes then leading to preaching, which is not really expected by the market and by those who are supervised. By the way, let me say that I'm still surprised by the fact that there is so much expectation towards the data protection authorities, especially towards the European Data Protection Board, that European Data Protection Board will be leading by giving the guidance to each and every possible situation and each and every problem that may exist in the GDPR. Throughout the whole process of preparing GDPR, we've been asked not to over-regulate, not to go too deep into the details. So in this sense, right now, waiting for the data protection authorities that they will themselves say what is the best way of doing the things is a little bit illogical, because the whole logic that I understood over the GDPR was that the controllers should be accountable, which means that they should know, and they said to us during the whole consultation process, that they know it better than the data protection authorities, how to deal with data protection in their sector, in their technologies, in their organizational matters. And of course, the data protection authorities are then to assess. So I don't see the role of the data protection authorities as being the head of the mob going into the direction of the good solutions. Now, we don't want to be the kings, we don't want to be the emperors, we don't want to be those who are showing where is the light to go to. We rather want to be the regulator, which means we want to cut those things which are bad on one side and on the other side, and to allow the market to develop the way that it exists.
Anyone else on this point? Otherwise, I open it up for the floor. With Julie, I see Richard.
Yeah, just really quickly. I certainly empathize with what you're saying, Wojciech, but I got to tell you, one good guidance is going to avoid thousands and thousands of problems. So if you really do, and I don't mean you in particular, I mean any regulator doesn't utter anything about its interpretation of the law in an ambiguous area, you're gonna be doing a lot of enforcement there, and it could end up being enforcement that could have been obviated by a good guidance. So, and it also sort of leads me to a puzzlement about your view of the role of the guidances that the DPAs have issued, which is that it was essentially like an accountability tool for the DPAs themselves, a harmonization tool, which I find super interesting, but you've got to realize that businesses are looking at them very closely, and I would hope that you would want businesses to be looking at these guidances closely in order to understand, look, if there's an area where the DPAs disagree, there's going to be an area where where businesses also need some clarity too. So that's all I'll say about that. There is another point I'd like to make about the market issue versus the fundamental rights issue, if we have time.
Well, the relationship between carrots and sticks, Julie's already made, I think, some very important points there. 9 years ago, I spent 2 years arguing the case for the ICO to have the power to impose fines of £500,000, and that was a big step towards what's now in GDPR. So I absolutely take Julie's point. There's a link between the powers you've got and the leadership role. In the paper somewhere, I think is it Benjamin Franklin, one of the great American leaders, who said somewhere, speak softly, but carry a...
Teddy Roosevelt.
I'm corrected, Teddy Roosevelt. Talk softly, but carry a big stick. We used to say, we've got a stick, but it's in a glass cupboard with a glass front, so you can see it's there. Somebody put it nicely, carrots and sticks, you need a very sharp carrot.
The sharp carrot. This is the quote of the day, probably. Can I open it to the floor? You want to say something?
No, maybe I was the one who used the words carrot and stick, as I remember well. what we are struggling with is that we need you could say a multi-track approach. And what makes me tick at the end of the day is leadership, and is hammering on the topic of fundamental rights. We all agree on that one. But right now, businesses and the governments in the Netherlands are looking towards us and literally saying, stop about fundamental rights. We know about it, but now tell us what to do. So what we need are resources to tell it indeed, to inform, to guide. That's what we're asking for. And what we need is authority. And the authority we not only get from the way we show knowledge, we show that we understand what is going on, there are problems also. But at the end of the day, also the thing that we have defining power, that we have enforcing power, that we are, at the end of the day, also the police with a strong stick. That's the multi-way approach that I'm talking about. And either the carrot nor the stick can do without the other.
Okay, thank you, Wilbert. We don't have much time. I would keep the question, the subject by Elise and Julie, not to be forgotten. But first, a question from the floor. Yeah. And please tell your name.
Thank you. Niels Leopold. I work with the Bundestag for the Green Party. Thanks, Julie, for getting the thing going and just pushing them. And it's very important.
That's what I always do.
Keep pushing those DPAs, and they need it. And I think also it's very interesting what Elise said about opening up to communicate, a wider communication, and making the DPAs aware of their communication role, which is also basic. And Richard, for saying all those things that in some authorities, like for instance in the northern of Germany, were already practiced. I think what you listed up as points of how to organize a DPA, they have been practiced over the last years in certain very small authorities, and it's their knowledge of how to carry out their work. I find it so interesting that we are discussing this GDPR now, but we had the directive for many, many years, so it's always the word about evolutionary here, evolutionary. So, but we had this directive out, and the DPAs were forced over years to organize themselves, many of them, and they did. But it's maybe a minority, and now we have this new discussion about how to get the job going. I find that so interesting that we start anew. My actual question was, when I read about what was it, oversight?
Regulators.
Smart regulators, I actually thought they would have like digital devices to carry out their work. There was actually a discussion about that a few years ago. Like for instance, checking websites and the data protection regulation on how to, for instance, explain who's responsible for the website and stuff. So that the question would be for the DPAs, the two DPAs on the panel. When you look at all these different aspects of your job, is this something that has to have a consequence on staffing these DPAs? Have we discussed this enough? I feel that you come from the tradition of administration, very traditional administration, but is this really also about staffing and finding those people doing this communication job?
Okay, I think, are there any other questions at this point? Simon? Then we answer them all together at least.
Simon Ania, TomTom. The relationship with the DPO. So the expectation of the Data Protection Authority is in the law. What are the hopes of the DPA that DPOs will achieve?
Any other question at this stage? Otherwise, maybe the two of you start with answering and then we continue.
Well, of course, if you ask, are we taking care and are we thinking about the problem of staffing the data protection authorities and especially staffing which is understood and resources which are understood not as the number of people working in the office, but first of all the skills and knowledge of the people who are working in the office. Yes, we do. are some data protection authorities which made interesting solutions in the in last years. I have to say I was always astonished by the development that French CNIL did the last 8 years as far as the IT knowledge of the people in the office is concerned. And also some years ago, being the data protection authority in my country of origin, we made a special study visit to there to find out how was it possible that having more or less the same resources as the other data protection authorities around, they were able to build the laboratory working there. They were able to build the group of people that can really talk with the market. And the other very good example is one of the data protection authorities that you probably thought about in Germany. I mean the Schleswig-Holstein authority, where the DPA herself, Marit Hansen, who is, by the way, present at this conference as well. She is not a lawyer, she is an IT person. She is an IT person who makes the small data protection authority, one of the land authorities in the bigger country, really active in this ground. One more sentence only. The synergy between data protection authorities is something to be achieved. Synergy, which means that not all data protection authorities have to do all the things, because it's simply not possible because of the resources. But if we will be able to divide the work or to somehow distribute the work among the data protection authorities in Europe the way that there are ones who are more developed in some fields, that might be one of the lessons that we may learn from the German data protection authorities that already do it in the Düsseldorf group and among themselves.
Thank you very much. It was your last remark.
Yes,
Wilbert, quickly on the question of Simon Hanja, and then I will ask Elise and Julie to say something on markets and fundamental rights, and finally, Richard.
Okay, I will get to Simon and the DPOs in a minute, but allow me one reaction again on this idea about the DPAs being quite traditional and the technologies they use themselves. We are, next Sunday, the 28th, is International Privacy Day, and on the 29th we will start our campaign in the Netherlands, and as I mentioned before, we even go on TV and whatever with ads to inform the general public. And what we wanted to do is make use of all kind of websites and all kind of innovative ways of reaching out to the general public. And what we did was have our technology, the colleagues from the technology department, look into all those websites and all what have we got. And they almost about every website came back to our communication department saying, but you can't do that. The way they handle privacy, the way they handle personal data, you can't use this site, you can't use that site, you can't do that. So we basically are going to be on TV and radio and not spoil whatever person. So that's about the innovative acting from our side. As it comes, Simon, to DPOs, DPOs are, and I hope you know it by now, for us in the Netherlands, extremely important. We see them as ambassadors. We see them as our main contacts within companies and governmental bodies, of course. We already had quite a big meeting for DPOs at our office, and we are going to organize another one. We are trying to have a very close contact and close relationship with DPOs, which for me are of an extremely importance.
Thank you, Wilbert. Elise.
No, I think you should go.
So Elise asked me to go first, which thank you, very sweet. The one thing I wanted to throw out as a kind of a challenge for the DPAs for the future, and this goes to the point of what are fundamental rights that you're going to be examining. The fundamental right of privacy and the fundamental right of data protection has to include security. You can't have privacy without security. The GDPR recognizes that security it's a part of the GDPR. And now the NIS directive is going to be going online. I think one of the things you're going to need to be thinking very deeply about is the extent to which data and personal data is going to be needed in order to ensure security of data. And it's very complicated, and I can tell you that I heard a lot about it at the FTC. I'm learning an awful lot more about it inside companies. And privacy is, if you look at privacy in isolation from cybersecurity and data security, you will not be doing the full job of actually protecting the privacy of data. So it's going to get even more complicated, which just to the point of our friend from the Bundestag, the FTC also, like the CNIL, had a large technology office. I think you're going to need that even more so.
It's not large. They are very effective not being large.
When I said, okay, I agree with you.
Could
We
you,
need a chief technologist and then a couple of others. It's important to have technologists on board because they're going to be able to answer a lot of these questions. Thank you.
Thank you, Julie. Elise?
Well, just a word, not to take you away from the coffee break. No, I think it's important what Julie just said. But basically, I think if you're thinking about strategies on how DPA should organize their work in the future, which I think Richard and Hielke are trying to do, it seems to me that the plurality of actors you can involve in your reflection could be improved. Like to me, at the moment, this is really very, very focused on a market regulators approach. But I think what Julie just said about security or broader concerns of other types of fundamental rights, not to turn into an obsession for fundamental rights, just to ensure a more balanced approach to these various interests. But congratulations and thank you again for the papers.
Thank you. I think we need to come to a close. Richard, and the very last word, of course, will be Caroline.
Just a very quick point. I thought within the last question was perhaps the absolute central point for this afternoon's discussion. What results are DPAs trying to achieve? I think above all, they should spell out what results they're trying to achieve. Whatever any authority is trying to achieve should be spelled out. And that really is another aspect of accountability, because in essence, we're talking about accountable data protection authorities. And there is no tension between the independence of the authority and its accountability. If you just say we're independent, nobody can know, nobody can question what we're doing, then I think you're in trouble. If you can be transparent and spell out the results you're trying to achieve, then everyone knows where they stand.
I think this is the perfect final remark, but Caroline, you are entitled to say a few things.
I want to exercise my right. So talking about complexity, talking about broadening the conversation, we've been focusing on DPAs and how they can maximize their effectiveness to achieve smart data protection. But what about judges? What about courts? They will also have to apply the GDPR, and have they even heard about it? How do we make sure that they do understand the GDPR? And how do we make sure that they adopt a consistent interpretation across Europe? So that's going to be a next paper for the CIPL. Thank you very much.